And with that, we're going to move into the third session of the conference, and that's the session on copyright limitations and exceptions. Mr. Raghavendra has very kindly agreed to moderate this session, and the first two papers that will be presented are Pranesh Prakash on parallel imports and Abhishek Malhotra on involuntary licensing. So I would just like to remind the speakers that we have a maximum of 20 minutes per presentation and then a short time for questions right after. Thank you.
Sorry for the interruption, and I've come to know from the organizers that we have to be strict with time, and 20 minutes allotted to each speaker. Okay. So I just indicate just 2 minutes before you finish to just sensitize you that.
Okay. Thank you.
Yeah, thank you.
That'll help. And I think I might need that sensitization today since it's a longish paper. So I'll skip over one part of the paper, which is on establishing why international exhaustion is a good idea is a good concept to be followed in Indian copyright law. And as a developing country, as a country that's about to be, that's looking for at the verge of electronic distribution of copyrighted material, etc., I believe that international exhaustion is good for India, but that's not something I'll go into today. Right now, I'll focus on the parts of my paper where I look at how, in my belief, we currently do follow international exhaustion, and this I do through looking at various negotiating texts, India's position in different negotiations, looking at a string of cases, including the Penguin case, looking at the Eurokids case, looking at the VG Santosh case, etc. Then also looking at the 1994 amendment to the Act, how that substantially changed the position, and then looking at a few cases dealing with export. And it must sound like an old curmudgeon here, but I think pretty much all the cases we have on this issue have been decided wrongly. So, and I hope to convince you as well that that's so. So quickly, what is the doctrine of exhaustion, or the doctrine of first sale? It's the idea that once a book has been sold, once you physically own a book, then certain kinds of rights in that book have passed from the owner to you. So you can throw the book away, you can rip it apart, you can resell it, you can do whatever you want, as long as that one area that's carved out of certain kinds of rights reserved through copyright, okay, that is reproduction, etc., making a communication to the public in some cases, those kinds of other things aren't allowed. Okay, but with the physical copy of the book, you can do whatever you want. That's the idea. Now the question before us really is, how far is this idea applicable when the book or any other kind of copyrighted work was first published outside of India? So one essential part in answering this is, can foreign works be copyrighted works? So Section 13.2 of the Indian Copyright Act says that copyright only subsists if the work is first published in India, but then, or if the work is by an Indian citizen. But then there's sections 40 and 41 of the Act, and 40 allows for the provisions of the Act to be extended to foreign works and foreign authors by special order of the government. And since we are signatories to Berne and TRIPS and the UCC, we are required to do this, and we've done this through the International Copyright Order, the last such order having been published in 1999, as far as I can make out. Thus, for the purposes of our law, we protect not only Indian works, but foreign works as well. And I think this is, there's an important point to note here, that while we provide protection to foreign works, we also subject them to the same exceptions and limitations as Indian works, meaning that limitations such as that of the doctrine of first sale should apply to them as well. Limitations and exceptions contained in section 52, for instance, should apply to them as well, and I think that is an important point to recognize. What does the Copyright Act say about import of copyrighted works? Well, Section 51B4 does talk about it. It makes illegal the importation of infringing copies of a work. Now, the way I read this is that a work can be a pirated copy, and it prohibits the import of such a pirated, infringing copy of a work. So it's clear that illegally published copies are infringing copies and thus cannot be imported. And according to Section 2M of the Act, which talks about what an infringing copy is, something is an infringing copy if such reproduction, copy, or sound recording is made or imported in contravention of the provisions of this Act. So 2M doesn't clarify matters either currently, because it only applies to that importation that is in contravention of the provisions of the Copyright Act. And what does contravention mean? It becomes a little bit circular, because now we have to again look at Section 14 and Section 51, which I'd already mentioned. So Section 14 Section 14, importantly, does not anywhere grant a right to import to the copyright owner. But Section 14 does lay down that insofar as literary, dramatic, or musical work go, if it is the copyright owner's exclusive right to issue copies of the work to the public, not being copies already in circulation. And then the explanation to that section clarifies that for the purposes of this section, a copy which has been sold once shall be deemed to be a copy already in circulation. What does this mean? And does the circulation have to be circulation in India, or is circulation abroad also covered by this provision? That's in essence the question that courts have had to answer, and let's note that this particular wording is what's present after the 1994 amendment. So I'll start with, since I don't have too much time, I think I have around 10 more minutes left, so I'll quickly give a run through of the cases. In a pre-1994 decision, the Penguin case of the Delhi High Court, the court ruled quite bizarrely, I must say, that it constituted that such importation without the permission of the copyright owner constituted infringement because it constituted a violation of the owner's right to publish. At that point in time, pre-1994, Section 14 spoke about the right to publish and not the right to issue copies of the work. Okay, and it held that it was an infringement of the right to publish. I don't think I really need to go into this right now, but let me just note that there are two bases really for this. One is privity of contract. Okay, the idea that if I sell a book to you, right, then the contract between us cannot bind someone else. Whenever I enter into a contract with you, that cannot bind someone else. Now, this is one of the bases for the Bobbs-Merrill judgment, which was the 1908 case of the U.S. Supreme Court, in which there was a notice on the book that was being sold, saying it shall not be resold for less than such price. And it was being resold for a lesser price. And the court held that that kind of imposition wouldn't hold valid, because amongst other things there was privity of contract, and there was another ground as well, which is the doctrine of first sale and the ending in essence of the right to property on the one hand, that is my right to the physical property of the book, and the right of copyright owners of copyright. Quickly moving on, the 1994 amendment to the Act was thus necessitated. It was an attempt to overturn the Penguin judgment, and one would think that this would suffice. And we in section 40 also make it clear that all and any provisions of this Act shall apply to works first published in any class, territory outside India, to which the order under section 40 applies, in like manner as if they were first published within India. So under this legal fiction, under section 40, even books published internationally are akin to books published in India. Next, we come to the Eurokids case from 2005 of the Bombay High Court. Unfortunately, it has even less reasoning than the Penguin case. So what we find here is that they don't even refer to the 1994 version of the Act. They don't even refer to section 14. They don't even analyze it and say how it applies to the case. What they do instead is refer back to the 1983 judgment of the Delhi High Court and saying, okay, so here's that judgment, and clearly because of that we can't allow for parallel importation. That's simple. They don't even notice the fact that the law has in the meanwhile changed. And because of this, I feel strongly that the 2005 Eurokids case is actually per incurium, meaning that it cannot act as precedent because it was passed without reference to the appropriate law. Since I don't have too much time, I won't go into the Warner Brothers case, which was specifically a case about importation of DVDs. But let me just note that I disagree with the final finding of this case as well. And I'll quickly get to the issue of export of copyrighted works. Now, let me rephrase that. No country that I know of actually regulates, through its copyright law, export of non-infringing works. In the US, through Section 602 of their Copyright Act, they regulate the export of infringing copies, that is, works that are manufactured without the permission of the author. They restrict that. In a few other Latin American countries, through judicial interpretation, they have similar restrictions in 3 different Latin American countries. However, the fact is, in India, we now, through the John Wiley and Sons versus Prabhat Chandra Kumar Jain case, have recognized, in essence, a right of export in copyright owners. Now, the facts of the judgment are rather simple. John Wiley and Sons exclusively licensed rights over certain books to Wiley India, and there were others as well, but I'll restrict myself to Wiley here. These books were sold at a reduced cost in an Indian market and were clearly labeled as being Wiley student editions, restricted for sale only in Bangladesh, Myanmar, India, Indonesia, etc. And another label on the same book read, the book for sale only in country to which first consigned by Wiley India Private Limited may not be re-exported, for sale only, and gives a list of countries. Now, quite clearly, John Wiley and Sons, being owner of the rights, had given exclusive license to Wiley India Private Limited to publish and print an English language reprint edition only in territories in this agreement and not beyond that. That restriction, importantly, is on Wiley India Private Limited. Further, they wish to impose this restriction on all buyers of the book by way of that notice and attached conditionality, and thus prevent exports to the US. Now, obviously the case I discussed earlier of Bobbs Merrill must come to your mind, where a similar notice in 1908 was held to have been invalid, and that is currently the law followed almost universally, that of the doctrine of first sale. Unfortunately, that's not how the court sees it. In a very detailed and circuitous judgment, Justice Manmohan Singh rules that the activity done by the defendant is a violation, not of some implied contract between Wiley India Private Limited and him, but that it constituted a violation of the Indian Copyright Act. So he doesn't hold it to be a violation of contract, saying that I've sold a particular book and reselling of that book elsewhere is a violation of this notional contract. Okay, because at that stage we can look into how property rights in that book will collide with this nominal contract, etc. But he calls it a violation of the Copyright Act, and notably Section 51 of the Copyright Act. How does he come to this conclusion? His reasoning rests on three dubious pillars. One, that the rights of the licensee are distinct from that of the owner, and that the former may get exhausted without affecting the latter. Meaning that the rights of the owner may get exhausted without the rights of the licensee being exhausted. Okay, try and grapple with this idea in your mind for a minute and savor it. Two, that the licensee cannot pass on a better title to those that buy from him than that which he himself has. This is the idea of nemo dat quod habet. You can't pass on a better title than what you have, right? Third, that sale or even offer for sale or taking of orders for sale are all forms of putting into circulation or issuance of copies. So, according to his judgment, doesn't need to you don't need to actually sell the book. Even an offer for sale is sufficient to make something, putting into circulation or issuance of copies. Now, just attacking the middle ground first, okay, the idea of nemo dat quod habet. The licensee, what role does the licensee play here? The licensee gets a license to publish a book in India and a few other countries. That right, when the licensee wants to, say, okay, fine, I have this right to publish the book, but I actually want someone else to do the publishing for me, okay? In that case, the licensee can't do that outside of India. The licensee can't, for instance, get the book published in Australia, because the licensee's rights are restricted only to India. However, what the licensee is doing by selling the book isn't passing on title in the book, because the licensee is actually just selling the book. He isn't subcontracting the license. He isn't entering into a new license when the sale happens. So the book is being sold, and the person who bought the book is selling it elsewhere. Okay. Now, if we are to take and that can't be covered by the idea of nemo dat quod habet, because it's not a license taking place, it's a sale that's taking place. There's a substantial difference. One would be of copyright. One is a sale of the physical book. And the judge, unfortunately, conflates these two into one idea. Now, in 1908, in the Bobbs Merrill's case, these two were clearly separated. But unfortunately, in the 2010 case, now again, they've come together. So, what that in essence means is that the judgment is fatally flawed. It's based on a lack of understanding of copyright law, frankly. And since I'm running out of time, I'd like to actually reserve some time to invite comments on this. Would that be fine?
You have 2 minutes, so why not?
Okay. I think I'm wound up already. So, so any comments or? Okay, actually, I'll just wind up by making one comment about the implications of this judgment. What this judgment in essence does is negates the idea of the doctrine of first sale. And it does this, and nothing in the reasoning actually applies only to foreign books. Because every part of these 3 pillars on which the judge bases his reasoning, that of rights of licensee being distinct, that of cannot pass better title, that of offer of that sale or even offer for sale constitutes issuance, is applicable equally to Indian works. So that means that someone can say, someone can divide India up into 50 different territories or 100 different territories, and say that this particular book that I've sold with this condition can only be sold in one part of Andhra Pradesh. So if I buy it there, and then if I go to Bangalore and I want to resell it to a second-hand bookstore, then I would be in violation.
Have you ever drunk a bottle of beer?
Sorry?
Have you ever drunk a bottle of beer? It says sale only in Maharashtra.
Yeah, now that's about taxes, okay, and sale only in Maharashtra. If it happens elsewhere, the tax regime on that will be different. The pricing would be different. Okay, it's not a matter of and this is precisely what went all the way up to the U.S. Supreme Court, because a watch, an Omega watch, had the Omega logo, which they said. So this watch was imported from Switzerland, was being resold in America, and they were saying that it can't be resold in America without our permission. Okay, so I don't want to live in a world where every time I resell anything, I need to take permission of the person who produced it. That would completely negate the idea of sale. That would completely negate the idea. And please note here that what is being restricted is not sale. What is being restricted is resale. Okay, so the people had bought it from Wiley India Private Limited. Okay, that wasn't the act that was in contention. What was the act in contention was them reselling it. Okay, now, do you mean to tell me that a bottle of beer that is bought in Maharashtra with appropriate pricing being paid can't be resold in Karnataka? For however, like I buy a 20 rupee bottle of beer in Maharashtra, if I want to go to Karnataka and sell it for 100 rupees, there's no law in India that prohibits me from doing so.
No, what you are addressing is the problem of parallel imports. I think that is the point you want to make.
And the doctrine of exhaustion more generally.
Some law. Vast subject which have been...
I was just wondering if you could tie in your yesterday's talk, TPMs, and sort of link it to region-encoded DVDs. And then purchase of DVD players which can play irrespective of what they're encoded. So I guess you could then...
So just the one idea being that parallel interpretation shouldn't really fit in there. It's more, I see that more as a TPM issue than a parallel importation issue, though it might, though the Warner Brothers case might complicate things a little bit, and I have my own reason for why that was decided wrongly, even though I must admit the reasoning in the Warner Brothers case is much more exhaustive, is much more plausible. I still disagree with it, as I explain in my paper, okay, but it's for different reasons. Now, to simply answer your question, in India, my understanding of Section 65A as it exists now is that it would be legal to break region encoding, because there isn't anything granted in the rights in Section 14, read with Section 51, that would make it, that allows for that kind of restrictions on distribution. Okay, the second part of that would be that even if that weren't so, at least for personal viewing, okay, and the word used in Section 51, 52, 1A is use, okay, and now it says personal and or private use. It would definitely be allowed at any rate. So.
We have time for just one more question.
Sure.
There's one question on, and it stems from the Warner Brothers case, but and the Warner Brothers case, Justice Bhatt clearly recognizes the first sale doctrine, principle of exhaustion vis-a-vis literary works.
Yeah.
So to that extent, if this issue were to come up again in the context of the 1994 amendment and the right to issue copies not already being in circulation, I think that's a fairly sort of, it would be easy to argue that your case was wrong and Penguin is no longer good law. But is there, in view of the distinction in language used between 14A3 and 14E3, 14E2,
E2, yeah,
where it only talks about any copy, is there a case for a distinction in treatment of the derivative work and the underlying literary work with regard to this principle of exhaustion?
So I'll just talk about the way that the law existed when Justice Bhatt issued that judgment, was to sell or give on hire or offer for sale or hire any copy of the film, regardless of whether such copy has been sold or given on hire on earlier occasions. Now, this has been amended since, right? But this was the version that existed then. Now, if we take this literally, then it could mean that I could take one copy of a DVD, sell it to you, okay, and then take that same copy back from you and sell it to some other person, because it says to sell or regardless of whether such copy has been sold on earlier occasions. Now, clearly, that can't be what the law means, because that would be quite absurd. Okay, that I can sell you something and sell the same object to someone else and sell the same object to a third person if I have the exclusive right to sell. So you have to, somewhere in here, allow for a sale to actually have taken place. Right? So, and if we do that, I think automatically the doctrine of exhaustion will creep in.
Just the other way of arguing it, because it is an exclusive right, so not only, it's more the right to exclude the others from doing that, right? So if once I have sold that someone else, I can still limit that person's right to further resell, is what the interpretation could be. I'm not saying that there is a complete clarity with regard to that provision. I'm just saying that the language used in both the provisions gives that scope for interpretation, that there is this differentiation in the two types of works.
It does, which is why I thought it would be okay to skip through Warner Brothers in this particular presentation, since I have less of a problem with it than with the other judgments. But I still think that that's an unreasonable, that given that there are ways of reading this particular provision to give it meaning, and given that the way that Justice Bhatt reads the provision would lead to an absurd situation arising, I think the other way, okay, is the preferable way. Now, I'll also note that in the WIPO copyright treaty, with which we now seem to be compliant, in Article 7, there's the right of rental, which is specifically spoken about, and 7.1.2 talks about cinematograph works, and 7.1.3 talks about phonograms. Okay, but very importantly, these aren't compulsory. Yeah, and let me just...
You can continue if you don't mind.
I'll just wrap up
the coffee break. Yeah.
In one sentence. Importantly, these aren't compulsory. 7.2.2 2 says, in case of cinematograph films, paragraph 1 shall not apply unless such commercial rental has led to widespread copying of such works, materially impairing the exclusive right of reproduction. So we aren't required under the WCT to give such an exclusive right either.
I would like to Mr. Pranesh Prakash. Please give him a big hand. I respect his knowledge, especially in this area of subject parallel imports. He has been doing a lot of work in this, and we all know that Article 6 of TRIPS talks about the flexibility of the exhaustion, international, national or regional exhaustions. It's the same framework we have adopted in the WCT and WPPT, including the recent Beijing Treaty audiovisual performances. And then that's what we fought against introduction of this thing, limitation on exhaustion in the limitation exception, visually impaired, saying that you cannot apply exhaustion principle here. You can apply it to the distribution right, but not to the limitation exceptions. Our discussion is going on. I'll give you an example of a famous study done by the New Zealand government, and after introduction of international exhaustion in the copyright law, how it works in the 5 years of period, and then its impacts in the public industry, publishing industry, cinematograph, film industry, and music industry, including software. This study clearly gives a lot of empirical data that these industries did not collapse, they survived. In fact, relatively their earnings were better than before the introduction of parallel imports, especially international exhaustion. That's what we try to do in amendment to Section 2M, but the question came, where is the empirical data to support that? That's what we are doing. We are having a study done by NCAER. Hopefully in a month's time the report will come, and government will take a final call on that.